You're at a deposition in your case, and another attorney is asking you a question, and your attorney yells out, "Objection! Vague question! Don't answer that question!" How can your lawyer's objections help you in giving your best testimony at deposition? Hi, I'm Frank Nunes, a civil law trial attorney practicing law in the state of California. Join me as we explore the reasons and ways that a lawyer's objections can help you give your best testimony. A deposition is a process where people answer questions asked by a party or that party's attorney under oath. It's usually done in an informal setting, but it carries the same weight and force as if it were done in a court of law. In fact, the beginning of the deposition often requires, or always requires, the witness to take an oath to tell the truth. So it's very important that the witness give his or her best answers to every question and that the question be properly worded. Your lawyer will be with you to defend your deposition. When he or she objects to that question, he or she is doing their job to make sure that you have a good question so you can give the best answer and your best testimony if the matter should proceed to trial or arbitration and that testimony is used later in your case. But listening to the attorney's objections can give you clues as to the problems with the question asked to you. For example, if the lawyer says, "Objection, the question is vague," then you know that the question isn't clear. If you don't understand the question that's being asked of you by the other attorney, think about it and sometimes ask the other attorney, "I don't understand. Can you please rephrase the question?" Most attorneys are happy to do so or to expound on what the question is asking for. The other objection you hear quite often is, "Objection, the question is compound." And what that means is the attorney asking you the question is trying to get multiple questions into a single question for you. So if you answer the question, "Were you speeding and running the red light?" and say yes to both of those, then you are in fact admitting that you were speeding and running the red light. Whereas there should be a question that asks, "Were you speeding? Yes or no? Did you run the red light? Yes or no?" Because you may not have done both of those actions. That's the example of a compound question where somebody is, or usually an attorney, is grouping more than one question into a single one. And it can confuse a witness, and the most important problem is it leads to a vague answer. Which question was the witness answering? The other common one that you'll hear an attorney say is, "Objection, it calls for speculation." As a general rule, you're allowed to give your best estimate as to specific dates, times, amounts, distances, locations, etc., but at no point is a witness allowed to guess. The law does not want people to provide guesses at testimony, at trial, or at deposition. So the difference between a guess and an estimate typically involves some factual basis. The common example I use, if you ask someone to tell you how much money do they have in their wallet right now without looking, they can give you an estimate. If you ask them to tell you how much money another person has in their wallet and they've never seen that person's wallet, they'll have to guess. So there's the difference between guessing and an estimation. So when your attorney says objection, speculation, that tells you the question that's being asked of you is calling for you to guess at something you may or may not know. If the witness is already identified, have no knowledge of that area, and the attorney persists in asking questions of that, then all the testimony coming after that is going to be based on speculation and not useful and can actually harm your case. Finally, the last deposition objection you'll hear is sometimes it calls for a legal conclusion or an expert opinion. And as a rule, most people can give lay opinions. How fast was the car driving? Did the person look intoxicated? Was the lighting well lit that day? Those are things that just about everyone is qualified to give an answer to. But when somebody asks, well, did the impact cause your injuries? Or would you have gone to the hospital as long if you had done a different type of treatment? That is something that's asking for the opinion of someone who has qualifications, such as a medical doctor or a healthcare provider. Sometimes they'll ask, who do you think is at fault for the collision? And that will be where they're asking for a legal conclusion. Or who do you think violated this contract? Again, that is where they're asking the witness to give a legal conclusion. As a non-lawyer and a non-expert witness, those types of questions can be improper. Well, that's it for today's video on how your lawyer's objections can help you at your deposition. By the way, if you found this information helpful, subscribe to our YouTube channel. Why? So you can continue to get great new content like this every time we post another great educational video. And if you have questions, I want you to pick up the phone and call me. I can answer your questions. I answer questions like this every day. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.